Supreme Court made a highly anticipated ruling today, just 5 weeks after hearing oral arguments in one of the nation's most restrictive abortion cases. It may well be another sign that they're on their way to rolling back abortion rights in America. In an 8-1 decision, the court ruled that it will allow abortion providers to continue challenging a Texas law in lower federal courts, but it denied a request to stop the law's enforcement. It means the law remains in place while the case moves back to district courts. SB 8, which has been in place since September 1st, bans abortions after 6 weeks, which is before many women even know that they are pregnant, and it makes no exceptions for rape or incest. In a stinging dissent, Justice Sonia Sotomayor warned of copycat laws that could infringe on even more constitutional rights, writing this: new new permutations of the SB 8 are coming. The court cleared the way for states to reprise and perfect Texas's scheme in the future to target the exercise of any right recognized by this court, which they may disagree. And she made this comparison to pro-slavery crusader John C. Calhoun. This is a brazen challenge to our federal structure. It echoes the philosophy of John C. Calhoun, a virulent defender of slaveholding South, which insisted that states had the right to veto or nullify any federal law with which they disagreed. Chief Justice John Roberts joined the court's 3 liberal justices with this opinion: the clear purpose and actual effect of SB 8 has been to nullify this court's ruling. If the legislatures of several states may, at will, annul the judgments of the Court of the United States and destroy the rights acquired under those judgments, the Constitution itself becomes a solemn mockery. Today's ruling comes just about 1 week after some justices hinted that they may be open to overturning Roe v. Wade as part of a Mississippi case banning abortions after 15 weeks. The court makes a ruling on that case next summer. Joining me now to discuss is constitutional attorney and co-host of the podcast Boom Lawyered, Imani Gandy. Imani, I just want to get your take off the top. What was your reaction to the ruling today?
My reaction was frustration. You know, this is a case that is fundamentally about abortion. And reading the Supreme Court's opinion, you would think it was a case about civil procedure and a case about whether or not these abortion providers could sue this class of defendants or this class of defendants, and which class of defendants can avail themselves of sovereign immunity, and which classes are exempt from sovereign immunity under Ex parte v. Young. I mean, these were very sort of cerebral constitutional issues that didn't get to the nugget of the case, which is that this case involves an unconstitutional pre-viability abortion ban. Under current law, Texas's the law SB 8 is absolutely flatly unconstitutional. And the Supreme Court let it stay in effect. And that alone signals that the Supreme Court obviously the Supreme Court does not like abortion, but going more than not liking abortion, the Supreme Court seems willing to cede its federal power to the state of Texas in furtherance of Texas's bid to ban abortion in the state. And that's you could see that that was really troubling to John Roberts. And that's really a bizarre outlook for the court. And that tells you how disfavored abortion is by these conservative justices.
Right, and the reason it is so pedantic in some ways and talk about procedure is in fact that it is not really for them about abortion. They have kind of already made up in their minds that they are perfectly okay with seeing Roe be, withered away. The question for the court, it seems to me in reading that opinion, was that they are worried that this ruling could open the way for them, for states to do the same thing on other issues. That could include gun rights if the court were to change in some way. That could include any number of rights that we have now determined by the Supreme Court to be the laws of the land. Do you see this as a slippery slope case, or do you think that the court sees it as a slippery slope case and they don't mind being on that slope?
I think it's the latter. I think they know it's a slippery slope, and I think that they don't mind being on that slippery slope because they're in control of how slippery that slope is, right? We're talking about abortion rights. We're talking about a state that has enacted a law that violates a fundamental constitutional right. If we were not talking about abortion rights, if we were talking about, for example, Second Amendment rights, the right to bear arms, there is no question in my mind that the Supreme Court would have immediately blocked any law that turned over enforcement of a law infringing on the right to bear arms, turned over enforcement of that law to the public. So, when we talk about the rights that this court favors and disfavors, yes, it's absolutely a slippery slope if we were dealing with a nonpartisan court. But this is a court that is going to control which rights are favored, which rights aren't, which rights will remain constitutional, which rights won't. So, yes, it's a slippery slope, but they're not that concerned about it. Conservatives in this country aren't concerned
Right.
about it. Christian evangelicals in this country aren't concerned about it.
I found Sonia Sotomayor's invocation of Calhoun very interesting. You know, Calhoun was not just the guy who was pitching this idea of nullification, which was that the states could nullify anything coming from the federal level, from the courts or either from Congress. But Calhoun was like this staunch pro-slavery guy. He wasn't one of the slavery guys who said, you know, this is a necessary evil. He said, no, this is a positive good. You know, Calhoun is called by some people the father of secession, the man who started the Civil War, even though he wasn't alive when the Civil War started. I mean, is Sotomayor, am I reading too much into this, or is she basically saying what I believe is happening, that there is a new Civil War? It's not going to be fought in the fields, but it's going to be fought in the courtrooms. It's going to be fought in the state houses, where people go back to this idea that states can be separate from the rest of the U.S. and do as they please, even on the issue of human rights.
You're absolutely right. We are living in a world where there are states that don't believe that they are beholden to the Constitution. And we're also now, after reading the opinion today, living in a world where the Supreme Court doesn't seem to mind that states are encroaching on their federal power. I mean, ultimately, this is an issue about power, about the power of people to hear their grievances heard in courts, the power of the state to violate the Constitution blatantly, and then essentially, stare at the federal judiciary and say, well, what are you going to do about it? It's about the Supreme Court seemingly being willing to cede that power on issues that it doesn't really favor. If this were a free speech issue, or if this were a Second Amendment issue, we wouldn't be here. But we're on the cusp of banning abortion anyway, and so what's the big deal? We're just going to let this law in Texas remain in effect, and then come June 2022, this is all going to be over. This abortion mess is going to be over, and then I don't think we're going to see a lot of pushing for these sorts of private enforcement mechanisms in other contexts, because, as you said, it is a slippery slope, and those slippery slopes don't favor conservatives.
I have only 1 minute left, but I want to know if you think there's anything that Congress can do in this regard to help protect these women. The Senate is, still considering the Women's Health Protection Act. If they pass it, how do you think that will impact cases like the one in Texas, like the one in Mississippi?
Well, I mean, if by some stroke of magic Congress is able to pass the Women's Health Protection Act or codify Roe in some circumstance, then these cases become moot. But the problem is no matter what piece of legislation Congress enacts, it's still got to go through the Supreme Court. It's still got to make it past these 6 Federalist Society captured judges. So we're in a situation where we've got 6 conservative judges who are acting as a bulwark against protecting civil rights, protecting human rights, and that's a real concern.
Imani Gandy, thank you so much for joining me tonight. I appreciate your time.